friends.
And a very warm welcome and thank you for your time this morning, Michael Swain.
Good morning, Jonathan. Good to be with you and good to be with your listeners.
Thank you. So, Michael, today we're talking about hate speech in the context of the hate speech court case against Simeon, Chetty, a Christian evangelist in Chatsworth who is accused of hate speech after sharing his personal testimony in public and on social media. That hate speech court case against this Christian evangelist was in court last week. What can you tell us about it?
Yeah, well, the case took place in Chatsworth, in KZN, in a magistrate's court, which was serving as an equality court, because the accusation of hate speech against Mr. Chetty was in terms of the definition in PAPUDA. And remember, we've talked about PAPUDA before. It's also called the Equality Act. It's the Promotion of Equality and the Prevention of Unfair Discrimination Act. And he was basically taken to court by other Hindu organizations because they claimed that what he said was hate speech against their religion, against their faith. And we basically involved in the case as for as an amicus curiae, as a friend of the court, because we wanted it to be very clear and to make sure that the magistrate understood very clearly what the legal definitions of hate speech are. And especially how the legal definitions of hate speech has fortunately now been clarified thanks to two major constitutional court cases which have dealt with hate speech, which up to this point has been very much wider in terms of the PAPUDA or the Equality Act. The definition of hate speech has been much wider than the constitutional definition of it. And that has now been found to be, in fact, unlawful. And the Constitutional Court have effectively rewritten the definition of hate speech, which is much more now in line with the Constitution. So we were involved in that case to basically bring the correct understanding of the law. And as a consequence of that, or among other things, the magistrate encouraged strongly the parties not to actually bring this place to a point of judgment where he had to make some ruling on it, but rather to negotiate an amicable and mutually agreed settlement between the parties, which they did after quite some negotiation. And as a consequence, that case has now been settled. It is now done. The magistrate never ruled on it. There is no legal precedent. The agreement was simply made what's called an order of court. In other words, if the parties don't subsequently abide by that agreement, then they can approach the court again. But in fact, that case is now fortunately and happily settled. And we believe in a very positive way.
Sure, that is very good. So is it a court judgment or is it a court order that has been given?
No, it's a court
difference?
Well, it's a court order, and it's very important. The difference between the two is that if a judge or a court actually makes a ruling or a judgment, what they're doing is they're taking the facts, they're taking the applicable law, and then they're saying this fell inside or outside the law, and that then becomes a legal precedent, and they will give a rationale and a reasoning as to why they have made their decision, and that will also be based on law and can subsequently, of course, be used in other cases of a similar nature. Whereas a court order is a very different thing. It means that the parties have gone together and agreed as to a settlement, how they can work it out between them, which is always the best way, by the way, particularly in matters of faith. In matters of faith, you should never, ever ask a court, which is a secular institution, to kind of rule about what's right and what's wrong in terms of a faith or somebody's understanding of their faith or how they express their faith. And so this court order essentially is the court saying, well, we're glad you reached an agreement. We will make it enforceable. In other words, the agreement between you has now got some legal force, and we will make that an order of the court. If, therefore, you don't go ahead and do what you've agreed to do, then you can come back to us and we can then intervene again. But thankfully, in this instance, that's not going to be necessary.
Okay. Then just in terms of this whole court order and everything that's kind of transpired since last week, how does this affect the hate speech bill, which will make hate speech a criminal offense for which one can actually be sent to jail? And what is the status of the bill?
Well, the big development between when the hate speech bill came out the first time and it's now in fact before Parliament again potentially. It's gone back with lots of comments that were made last year, but it could well come back onto the screen. The big difference was that the John Quilani case, which was a case where John Quilani, who was a well-known journalist, he was at one point even an ambassador, he was quite a high-profile figure, made some very vilifying statements and comments in a newspaper about homosexuality and what he thought should be done about it. And that was under Papuda. And the Papuda definition, very importantly, was much broader than the Constitution. It talked about speech that was potentially hurtful. But the Constitutional Court said that that word hurtful, which we have argued for many, many years, is irredeemably vague. In other words, it's not offensive speech that gets you into trouble. Because everybody's going to be offended by something that somebody says. And you cannot have a society whereby you can go to court and literally bring penalties, let alone jail time, simply because what you said about somebody or to somebody is considered to be hurtful or offensive. It has to be a much higher standard. And so the Constitutional Court in that case said that it is something that you say against a person on one of the prohibited grounds. Obviously, there are protected grounds like sexual orientation and race and that type of thing. And that a reasonable person would understand those words to have a clear intention to be harmful or to cause harm and to promote or spread or propagate hatred. So, in other words, you have to say something like, for instance, kill the farmer, kill the Boer. Who do we want you to hate? Farmers. What do we want you to do to them? Kill them. That's a very clear illustration of hate speech. But simply saying something that somebody doesn't like or finds offensive, that in law is not sufficient. And there was a second case, which was the Masuku case, where, again, a very, let's say, hateful things were said about the Jewish people in that case. And again, the court reaffirmed the definition that they'd already put down in Quilani, that statements that are only hurtful will be protected. In other words, if you offend somebody, that's protected speech, because a reasonable person would not understand them to both have a clear intention to promote or spread hatred and to be harmful or to incite harm. So this is very important, because obviously the narrower your definition of hate speech, the more freely you can speak. When you have a hate speech definition that is open and almost anything you could say could offend somebody, and that will get you into trouble, then never mind that you actually might not end up in front of a court. Yeah. You almost start to self-censor because you just don't know what you might say or put on Facebook or social media or share in a meeting or something that might not end you up in court. And that has unfortunately been very much the way that we've been living since Papuda was passed originally in the year 2000. So interestingly, for 21 years, a legal definition of hate speech, which is something that affects really the fundamentals of society, was actually declared ultimately to be unlawful, i.e. too broad, and is now being amended. So we're very thankful for that. But keep an eye out for that hate speech bill, because it is going to come back. And the definition was too broad. It was still wider than the judge had said that it should be in the Quilani case and now the Masuku cases. And also the protection for religious speech we felt was inadequate. So we're going to keep an eye on that one. It hasn't come back yet, but when it does, you can be sure that we will let you know, because we are very much on the front lines of the fight for faith and freedom as 4SA.
Yeah, love that. Thank you so much. As we wrap up, Michael, where can people go to find out more and make sure that they are staying in touch with issues and situations that might affect our well-earned and rightfully religious freedom in our beautiful country?
Well, the best place to go, start off with, is going to be to go to our Facebook page, which is Freedom of Religion SA. And also, very importantly, our website, which is forsa.org.za. And that's probably the place to start, in fact, because you can sign up for our newsletter there. And we will then make sure that we give you direct alerts and articles and that sort of thing. We don't spam you, but we make sure that you know what's going on. And we need to be informed. So often, unfortunately, and the Papuda definition of hate speech was one such thing, like 21 years ago. I don't think anybody was watching this space. And there goes a definition which has really been used, I think, chillingly to stifle particularly conservative speech, maybe faith speech, you could say, over many years. Now it's been changed, thank God. But let's keep an eye on these things. We need to understand the times we live in and to be informed and be a place where we can respond when we need to.
Michael, thank you for your time. Michael Swain is the Executive Director for Freedom of Religion South Africa, and just updating us there with regard to the hate speech court case and the hate speech bill. We really appreciate your time, Michael.
Thank you, Jonathan. Great to be with you.